bringing the appeal, Morgan and others, against the Ministry of Justice.
Yes, Sir James.
My Lords, good morning. You have, I hope, the sheet giving you the representation of the various parties and setting out the timetable that the parties are going to follow in relation to their oral submissions. So I don't take you through that. I'm going to split our part of the submissions with Mr. McGleenan. He is going to deal with remedies and the questions about subordinate or primary legislation, and I'm effectively going to deal with Article 7 and Article 5, if that's acceptable. By way of introduction to this appeal, I don't propose to repeat the detail of the basic scheme that is in the Statement of Facts and Issues, and is also set out helpfully in the Court of Appeal's judgment, which you have at page 207 in the electronic bundle. The question that this appeal raises is whether Parliament is entitled, compatibly with the ECHR, to enact legislation the effect of which is to require those convicted of terrorist offences and sentenced to determinate sentences to serve 2/3 of their sentences in custody, and thereafter for their release to be approved by the parole commissioners on the basis that detention is no longer necessary for the protection of the public. The issue arises because the new provisions in that legislation apply to those already serving sentences in circumstances in which they were sentenced. When they were sentenced, the mandatory release point was at half-time, and there was no requirement for their cases to go through the filter of parole commissioners' approval in the manner that I've indicated. The case comes to this court on appeal from the Court of Appeal in Northern Ireland, which found that such a legislative change was incompatible with Article 7, leaving open the Article 5 issues as unnecessary for them to determine in the light of their finding on Article 7, and in circumstances in which, in the context of the same primary legislation, in Caen, the English Divisional Court reached a different view, effectively concluding that such provisions were compatible with both Article 7 and Article 5 of the ECHR. Just to touch very briefly on the key facts before coming to the Article 7 issues, the 4 respondents before you were convicted on guilty pleas of a range of terrorist offences. You will have seen from the appendix the nature of those offences, and you will also have seen the maximum penalties or sentences to which the court had available to it, ranging from life imprisonment in some cases to 10 years in other cases. In fact, the sentences were across a range from about 3 years up to about 4.5 years in terms of the determinate sentences imposed. They were sentenced on the 13th of November 2020. Mr. Justice Colton's sentencing remarks are in the appendix at page 398 and following. I'm going to give you electronic references for the page numbers whenever. Article 7 of the two
copies of his orders that he made.
Do we have copies of those?
Yes, the orders he made. Whereabouts do we find those?
I'm not sure. If someone could find those, I'll give you the reference to that.
Thank you.
I'm sorry. Article 7 of the 2008 order required the sentence at the time to be for such term as, in the opinion of the court, is commensurate with the seriousness of the offence. That was the basic sentencing rule. And as you will see from the extract from Mr. Justice Coulton's sentencing remarks, if I can take that from our case at paragraph 18 on page 117 on the electronic page numbering. We've used Mr. Morgan's case as the example, and as you see from those sentencing remarks in his case, the judge concluded that applying Article 7 of the 2008 order, as I've indicated, the correct sentence reflecting the seriousness of the offence would have been 4.5 years, having regard to culpability, as the judge puts it. That was then reduced to 3 years on account of the combination of restrictions whilst on bail and COVID in the prison environment, plus the guilty pleas. So the reduction in his case was from 4.5 years to a determinate sentence of 3 years. Under Article 8 of the 2008 order, the judge at the time of sentencing was required to specify a custodial period at the end of which the offender was to be released on licence, and that custodial period could not exceed 1/2 of the term of the sentence. That was the legislative maximum, as it were. And so whatever the judge did in relation to that, in all of these cases, he sentenced up to the maximum, as it were, so half. But the remainder of what was left after the custodial period had been set would be served on licence, which would run to the end of the determinate sentence. And as I say, here Mr. Justice Colton in all these cases set the custodial period at the maximum of 1/2 of the term of the sentence, and the licence period therefore ran for the other half. After sentencing, in these cases, Parliament in Westminster reacted in particular to 2 terrorist incidents that had happened on the streets of London. The first of them at Fishmongers Hall, in which a number of people were stabbed and 2 people were killed, and the other in Streatham, where again a number of people were stabbed in a terrorist incident, and mercifully no one was killed. Both of those incidents involved people who had been convicted of terrorist offences and had been automatically released at the halfway point of their determinate sentences. It was that, therefore, that triggered the 2021 Act, which made the changes which are of concern to this court. That Act received royal assent on the 29th of April 2021 and entered into force the next day on the 30th of April 2021. And Section 30 of that Act introduced into the 2008 order, along with relevant consequential changes to that order, a new Article 20 capital A. And so, in effect, the Northern Irish position, the Northern Ireland position, was brought into line with the position as it was in England under the direct primary legislation, and that English position, as I say, was considered by the English Divisional Court, Mr. Lord Justice Fulford, Mr. Justice Garnham, in the Khan case, to which I will come. The purposes of the legislation and the changes made were, it might be thought, relatively self-evident, because what Parliament decided to do was to extend the halfway point as the point of automatic release or maximum release to 2/3 of the sentence, and to introduce a new requirement for those sentenced to serious terrorist or having been convicted of serious terrorist offences. It introduced a new requirement that they could not be released even after that 2/3 point unless the parole board in England or the parole commissioners in Northern Ireland concluded that it was safe to do so. The purposes are dealt with in a little more detail. If I can invite you to take up the Khan case by the Divisional Court in Khan. That is in Bundle 1, Tab 21, if you're in hard copy. Page 1037 is the page I want for this purpose, dealing with the purposes of the 2021 Act in making those 2 changes. Rather than reading it out, could I invite you just to cast an eye on page 1037 from paragraph 73 down to the end of paragraph 82 on page 1038, with apologies for starting with my submissions, but the only reason for doing so is because the court concluded that those were much the more compelling argument. This, is, of course, is in the context of a justification argument in the context of Article 14. You're not troubled with Article 14 now, but that's why the court was considering why it was that Parliament had introduced the two changes that it did. And the reason for going here now is by way of introduction to show you this court's analysis of the purposes and their justification. In answer to your question, I'm told page 470 of the electronic is the closest we get to it. These are the committal warrants.
And just looking at that then, that's the original order, is it? The 13th of November 2020, made by Mr. Justice Colton.
I think it is, yeah.
Yeah. So he orders in relation to Mr. Morgan,
yep,
that he be committed to custody for the period determinate custodial sentence, 3 years, being 18 months imprisonment and 18 months on license.
Yes.
And then what happens then thereafter? Page 471. Seems to be another order, also dated the 13th of November 2020, and where he orders then that the defendant be committed to custody for the period determinate custodial sentence, 3 years, 2 years imprisonment and 1 year on license. And so there appears to have been an amended order. Is that correct?
It looks that way, although it seems strange it's dated the 13th of November.
I was just wondering whether or not there was any hearing to establish whether the order should be amended, and indeed, just flicking down through it, then you get the next one, Mr. Terence Marks, at page 472, and but his order wasn't amended by Mr. Justice Colton, it doesn't seem. It appears to have been amended by the Court of Appeal.
Well, it does. I'm afraid I can't help you. Maybe those who were involved, more closely involved at the time, have a better place to answer those questions than I.
Well, did those who were seeking to hold the the respondents in custody, perceive that they needed an amended order from the court?
They may well have done. It looks as though something.
And were they correct in that perception?
Yeah. Well, my lord, my submission is that they wouldn't have needed formally an extra warrant, because the legislation had the effect that it did. But it looks as though someone concluded that.
And the effect is the same, namely to change the terms of imprisonment. 2 years imprisonment, 1 year on license, for instance, at page 471.
Yeah.
With 18 months imprisonment and 18 months on license.
With a later date, at least in relation to that one,
yeah,
when it was changed by the Court of Appeal. Although that certainly looks as though that's what occurred. If necessary, my submission.
Does that amend the judge's order?
Well, formally it does, but my submission is it doesn't need to. It wouldn't have needed to. I was going to turn to Article 7 directly, if I may, of the ECHR. As my lords will be very well aware, that article in its final sentence precludes a, quote, heavier penalty being, quote, imposed than the one that was applicable at the time the offence was committed. And what I propose to do is to go briefly through the relevant case law chronologically, with an apology, because quite a lot of that chronological analysis has already been done in the judgment of the Divisional Court in Caen. But just to pick up a couple of points relatively quickly and then come to pull together some submissions at the end of that exercise, if I may. But the basic theme of this case law we submit is that there is clear and constant case law, both domestically and in the European Court in Strasbourg, that indicates that changes to early release provisions do not offend Article 7 on the basis that the relevant penalty, the determinate sentence, remains unaltered.
Are we going to be returning to Article 8 of the order to see what the judge actually does and what considerations he takes into account and so forth?
My Lord, I wasn't proposing to, but no doubt we can.
Well, I think it may be useful if we do that.
Yeah.
Because it struck me that it's not, well, when you look at it, it doesn't strike me as being the same as a conventional sentencing exercise.
No. My Lord, can I ask those to give some thought to that, and I'll come back to it, if I may. So that's the core theme from the case law, and we also submit that there's nothing in Del Rio Prada in particular that alters that position of principle. On the contrary, Del Rio, which turned on its special and pretty extreme facts, reaffirmed that principle, and we ultimately submit that the reasoning of the Divisional Court in Caen is correct reasoning, and if necessary is to be preferred to the reasoning of the Court of Appeal in Northern Ireland, although the real question, it might be thought, is whether or not the Court of Appeal in Northern Ireland were correct to say that the differences under the system in Northern Ireland were sufficient to enable them to distinguish the reasoning of the Divisional Court in Caen. I start with the House of Lords decision in Utley, which is in tab 22 of the first volume of the Authorities, and it starts at page 1050. And if I could invite the court to just cast an eye down at least the first half of the headnote, so you can see what was involved in that case. So you'll see that the conviction in that case was for rape, and the sentence which was imposed was of 12 years. The maximum sentence available for rape at the time of the offences, and indeed at all points thereafter, was life imprisonment. The offences were committed before 1983, but the conviction itself and the sentencing only occurred in 1995. And between those two dates, i.e. the date on which the offences were committed and the conviction/sentence in 1995, the 1991 Act had been passed. It came into force in October of 1992. And what it did was to impose conditions on the licence pursuant to which prisoners might be released after serving 2/3 of the sentence. And the complaint was that as a result of that, the 1991 Act had breached Article 7 because there was a heavier penalty than at the time of the offences, because the conditions on the licence were not in place at the time of the offences. And the House of Lords reasoning one sees perhaps most clearly set out in the speech of Lord Roger, if you pick it up at paragraph 38 on page 1060, so you'll see that he and other members of the House of Lords focused on the maximum sentence which was permissible to be imposed for the offence in question, which was life. And they focused on the word applicable in Article 7, interpreting, as you see from the first sentence of paragraph 39, the word applicable as referring to the penalties which the law authorised a court to impose at the time of the penalties. That was the correct approach. They derived, all of them in particular, from the Strasbourg Authority, which was referred to at paragraph 41 on page 1061, Kerm and Belgium. And you see the quotation from that case within paragraph 41. And you'll see the approach reflected in the sentence that sits under that quote at the bottom of page 1061. One has to identify that sentence. You'll see the attempt to argue in paragraph 42 on behalf of the prisoner in that case that the approach should be to focus on what the court sentencing either might have done or did in fact do, and they reject that. Lord Roger rejects that, specifically relying upon the speech of Lord Carswell, as you see from halfway down paragraph 42, if you read from the sentence beginning as Lord Carswell shows to the end of the paragraph. And then perhaps the key bit of reasoning is in paragraph 43 on page 1062, if I could invite you just to cast an eye down that paragraph. And you'll essentially see that reasoning reflected in the speeches of the other members of the committee. See, for example, Lord Phillips at paragraph 22 on page 1056. Baroness Hale at paragraph 48 on 1064, and Lord Carswell perhaps most crisply at paragraph 65 on page 1069. So that's utterly in the House of Lords, and you'll see that the approach is a pretty stark one, which is to say we look to see what is the maximum sentence that could have been imposed, and then we do the comparison following the change in the law or policy that Article 7 sets up. Strasbourg didn't quite go down that line when the case went to Strasbourg. If you go forward in the bundle to tab 28, starting at page 1177, you will see the Strasbourg inadmissibility decision, declaring the application inadmissible. You'll see the composition of the European Court, including Sir Nicholas Bratzer, and the reasoning declaring Utley's application inadmissible starts under the heading The Law on page 1182. And you will see at least an echo of the House of Lords reasoning in the sentence which straddles pages 1182 and 1183. The court must therefore verify that at the time when an accused person performed the act which led to his being prosecuted and convicted, there was in force a legal provision which made that act punishable, and that the punishment imposed did not exceed the limits fixed by that provision. But then when they come to the substantive analysis more directly, that starts at the top of page 1184. And can I invite you to read that page rather than my reading it out? I've put a particular sidelining, if I'm allowed to suggest that, against the last two paragraphs on that page. But if you start at the top of page 1184 and read to the bottom, you will see the reasoning. So you'll see the distinction that they're particularly focusing on, drawing it from Hogben and the United Kingdom, between the now well-established distinction between, on the one hand, the sentence or the penalty, and on the other hand, those matters that go to the execution of the sentence. In Hogben, the change in parole policy effectively meant that the life sentence prisoner didn't become eligible for release on parole until he'd served 20 years of imprisonment, and that was the change in question. So there was no doubt that in Hogben he would have spent longer in prison than would otherwise have been the case, but there wasn't a problem under Article 7 because there was that principal distinction between the sentence on the one hand and those things that go to the execution, such as early release and parole and so on. And you see that reflected in the final two paragraphs on that page.
I suppose it comes down to the question as to whether the penalties that were imposed here included the custodial period, or whether it was just restricted to the overall sentence.
My Lord, I think it probably does when you get into that, and the question more acutely when we get to it, which I will, is whether or not the involvement of judges or the court at that stage and in relation to that matter is sufficient to cause an Article 7 problem. We submit not, but I'll come to that if I may. But you see here the examination of what penalty means, and they are plainly treating the determinate sentence in the Utley case as the penalty and distinguishing that from the regime by which prisoners could be released before serving the full term.
Is there any significance in the final sentence as the sole penalties applied? Sorry, the final sentence on 1184, as the sole penalties applied with those imposed by the sentencing judge?
My Lord, I'm not sure they build much on that. If the suggestion there is it all makes all the difference that a judge might be involved to some degree in that exercise. My respectful submission is that there, at least, they're not purporting to attach any great significance to that. They're simply noting what the penalties were. They happened to have been imposed by the sentencing judge, unsurprisingly. But the comparison is a substantive one between the penalty at that time and the position as it changed, whether by reference to policy or by reference to law. But that's, in any event, the reasoning in Utley, and you see the reason I take you to it, because it's at least different in some respects, from what might be thought to be the harsher reasoning of the House of Lords, which simply said you look to see what the maximum penalty was, then you look to see what the change was, and if the one is lesser than the other, then you haven't got an Article 7 problem. This is a more nuanced analysis, but it does draw, which is why I go there, that distinction between a penalty as in the determinate sentence on the one hand and those matters that go to the execution of the sentence on the other.
And the judge in Northern Ireland then, in imposing a sentence and in determining the licence period and the custodial period, does that judge take into account ordinary sentencing principles, retribution, deterrence?
My Lord, yes, he would do, and he would do.
Well, you're saying that we haven't. This is why I wanted to look at Article 8 earlier. And the answer is, I think, no, he doesn't.
Yeah.
Or shouldn't, at any rate.
Yeah. My Lord, I'm being handed a long note. It may be that I need a bit of time to absorb that before simply reciting it to you. I'm very alive to the question now. At the moment, at least, can I trace through the principles and then try and come back to it?
Could you just remind us the page for Article 8? Sorry, I didn't note it before.
It's 516.
Thank you.
Thank you. Abedin or Abedin was my next port of call. Tab 19 in Bundle 1 of the authorities. Page 1007. And this, you see, is February 2015. I should have given you the dates. The date for Utley House of Lords was July 2004. The date for Utley Strasbourg was November 2005. So 10 years further on, we're still in the domestic authorities, but by this point, Del Rio has happened in the Grand Chamber. So Abedin is the first consideration by the domestic courts of the significance, effect, and principles set out in Del Rio. But Abedin Divisional Court, you'll see Lord Justice Laws and Mr. Justice William Davis. And you will see the facts of it from paragraph 1 on page 1007 in the judgment of Lord Justice Laws. So again, it's a determinate sentence, 20 years imprisonment, release on licence in 2012, said to have broken the licence conditions, recalled to custody, and the complaint, in effect, the change that was complained about, was that contained in section 50 capital A of the Criminal Justice Act 1991. And you'll see the effect of that summarised in paragraph 1. So effectively facing another 5 years in prison because of the changes to the automatic release date. Question, does that cause a problem under Article 7? The court's analysis begins on that issue at paragraph 7 with the recitation of the provisions of Article 7, top of page 1009. And you'll see that the essence of the court's reasoning is in paragraph 8 on page 1009, if I can just ask you to cast an eye down that paragraph. Referring to the long line of Strasbourg authority which draws the distinction between the penalty imposed and the means of its enforcement or execution, and then cites paragraph 83 of Del Rio for precisely that distinction that we saw in Utley. And then a consideration of paragraph 89 of Del Rio at the bottom of that page. This wasn't, as you see from paragraph 9, the first occasion on which someone had mounted a substantially similar argument based on the changes made by section 50 capital A. There'd been a case called Robinson, which you have in the bundle, but you'll see the relevant analysis at paragraph 9. in Lord Justice Lawes' judgment. There the argument was based on Article 6, but it was effectively the same reasoning that led to the rejection of the complaint. There was an Article 6 problem. And then you'll see reference to the Utley case at paragraph 12. The summary of Utley, both House of Lords and Strasbourg, by Lord Justice Moses and Robinson is set out at paragraph 12, bottom of page 1010. And then you'll see the citation of the final two paragraphs on the page that I took you to in Utley, European Court of Human Rights. You'll see that quoted at paragraph 13. The principal attack in this case was based on Del Rio, and so he cites a series of paragraphs from Del Rio, and the conclusion he comes to in relation to Del Rio is set out at paragraph 17 on page 1013. No erosion in principle of the well-established distinction between the penalty imposed and the means of its enforcement or execution. Del Rio doesn't touch that, is in essence the reasoning. So that was the divisional court in Abedin, the first time that someone had had a challenge based on Del Rio, rejected by the divisional court. The Court of Appeal were troubled twice with this and refused permission both orally and on the papers in Abedin. See the next tab, page 1016. Essentially agreeing with that reasoning of the divisional court. See the judgment of Lord Justice Gross, page 1017. And he agreed in turn with the rejection on the papers of permission by Lord Justice Lloyd-Jones, as he then was, as you see at paragraph 6. So you'll see 3 lines into paragraph 6 on page 1017. I likewise agree entirely with the reasons for refusing permission given by Lord Justice Lloyd-Jones and respectfully adopt the points he made as my own. He said this, and then you'll see the distinction in paragraph Roman 1, drawn by Lord Justice Lloyd-Jones, that's the one from Utley. Del Rio Prado is different, Roman 2, and then you'll see that he, Lord Justice Lloyd-Jones there, is again interested in what I call the slightly harsher reasoning of the House of Lords in Utley. See Roman 3. So the Court of Appeal refused permission, and that therefore represented the exhaustion of domestic remedies, and off they went to Strasbourg. And the Strasbourg decision is behind tab 24, starting on page 1089. And this was effectively a challenge to Utley ECHR, as applied in Robinson, as applied in Abedin, post Del Rio. And in essence, what the European Court does is to uphold all of the key distinctions you've seen in the earlier cases. But this is an important decision, and I would respectfully invite you to read, if you would, quickly, page 1093, under the heading The Court's Assessment. Can I, I'm sure you've read this already, but could I invite you just to remind yourselves of the reasoning of the Court, that page and a half, as it were, finishing with the end of paragraph 36.
there's maybe quite a helpful statement in paragraph 32.
Yes.
In the first sentence.
Yes. That's the key distinction. And you'll see that the court then goes on from that place to analyse what was in fact going on in Del Rio. And you'll see in particular the final sentence of paragraph 33, the court's conclusion in Strasbourg was that what Del Rio was doing in terms of its analysis of the relevant provisions of Spanish law, the conclusion that they reach is that in Del Rio, the court had decided that the changes introduced had the effect of modifying or redefining the penalty itself. So all the provisions about remission under Spanish law were effectively analysed by the Strasbourg court, both in Del Rio and now as clarified in this decision, as actually altering the sentence itself.
I mean, I think they were true remissions, weren't they?
They were.
That if the person worked the 2 days, they literally got a day off the sentence.
They did. And you see that from 33 and 34, particularly the citation from 101. So it was, as it were, as though the remissions had been dragged in to reduce the 30-year sentence, and it was that was being messed around with by the changes. And you'll see the conclusion that they reach on that subject in para 35, second sentence. By contrast, maintaining the distinction that you've seen in Utley, see paragraph 36. And you'll see in particular the third or fourth sentence in 36, nothing in the court's judgment in Del Rio called into question the central proposition outlined in Utley, that where the nature and purpose of a measure relate exclusively to a change in the regime for early release, this does not form part of the penalty within the meaning of Article 7. The court is satisfied that that is the case here, where you're dealing with a determined sentence. My lords, then Del Rio. I can take Del Rio pretty shortly. That starts at page 1095. I can take it shortly because you have the very helpful analysis of Del Rio, both in Robinson in the Court of Appeal, Lord Neuberger and Lord Justice Moses, and I can't remember, but also in Utley and in Abedin, both domestically and perhaps more importantly in Strasbourg, as to what it was doing, what it meant, and so on. And so perhaps just to draw out 2 key points. The first point to draw out of Del Rio is the point from paragraphs 83 and 84, which you've seen cited in the earlier Strasbourg and domestic case law. Paragraph 83 in particular specifically confirmed, having drawn the distinction that it did, that where the nature and purpose of a measure relates to a change in the regime for early release, this does not form part of the penalty within the meaning of A7. So express and clear approval by the Grand Chamber of that core distinction. And the cases in which that applied included cases in which it would in fact have led to an extension, and sometimes a significant extension, of the period of time that the prisoner would have spent in custody. That's the first proposition. The second proposition is that in order to fall on the wrong side of that line, what is done by the change must, per paragraph 89, result in the redefinition or modification of the scope of the penalty imposed by the trial court. So it's actually got to be in nature something that affects that. As it was put, just to remind you, in Abedin European Court, bottom of page 1093, paragraph 33, whether the changes introduced had the effect of modifying or redefining the penalty itself. And of course, as you will have seen, we don't need to get into all of the detail because the relevant facts of Del Rio have been extensively considered in the European Court's judgment in Abedin, but it doesn't take much reckoning to work out that the facts of Del Rio were in any event pretty extreme.
So what's the penalty imposed in this case?
The determinate sentence of 3 years.
And what was the penalty imposed in Del Rio?
The Del Rio penalty, as analysed, was 30 years. It had been 3,000, but it got lumped together into 30, less the remissions that were built in. And what had happened was that those remissions were then taken out, and the court analysed that as being...
I mean, in effect, as I understood the court's reasoning, the 30 years was essentially defeasible as a penalty.
Yes.
Depending on the period of time that the person worked.
My Lord, yes, I agree, and that's why my Lord described it earlier as a true remission case. That was built into the penalty. That's the analysis, and that's the analysis post hoc in Abedin.
And then when the court changed the law, in effect, as Strasbourg analysed it, suddenly it was no longer. It
was like 30 years with no prospect.
30 years with no prospect.
Yeah, exactly. So those were the special features of the facts. My Lords...
Is it purely a question of looking at the headline figure? I mean, if in Del Rio, if you looked at the headline figure, it would be 30 years.
My Lord, my submission is it wouldn't, for the reasons we've just discussed. It would be 30 years with the remissions built in. That's the analysis that the Abedin European Court puts on it, and I respectfully agree. That's the penalty itself point, that the remissions are part of that, and therefore when the courts changed that rule, it modified the penalty itself. That is to be distinguished, as they did in Abedin, from changes which affect things that go to the execution of the penalty, namely early release provisions and their ilk.
And then how does one distinguish this case insofar as the penalty here has built in a licence period?
My Lord, because the licence period goes to the execution of the penalty, which is the determinate sentence. That's the submission. I'm going to come directly to my submissions, and that's going to be the first one, as it were. But just to alert you to the fact, I'm going to go to it in a moment, if I may, as part of the submissions, but it comes with a serious apology from us, and I'm sure others would share it, as it were, which is that we have found, belatedly, as it were, a decision of the European Court of the 20th of November 2022 in a Ukrainian or Hungarian-Ukrainian transfer case, which I'm going to take my Lords to. I hope that reached you electronically, but we've got hard copies if it didn't. But I'm going to come to that with apologies. It should have been picked up before our cases were put in. But I hope
is that the Kupinski?
Yeah, it is.
Right. Okay.
Well, that's the one. But just to make sure that you have that on your radar as the latest word from Strasbourg on Article 7.
I'm sure you're going to come to this, but as I understand, I mean, it might be said, might it, that one's playing around with how one conceptually sets this up. So if one says in the Spanish case, well, the sentence is 30 years less the remissions, you might say, well, the sentence in our case is the 3 years less the licence period.
My Lord, yes, you can. I mean, of course, I recognise that there's an element of your starting, as it were, with a blank sheet or a clear horizon. You can analyse it both ways, as it were, conceptually. But what Strasbourg has plainly done is to draw a distinction between the penalty on the one hand, which, to put it at its most basic tradition in relation to determinate sentences, is treated as being the determinate sentence, as compared to all those things like custodial period, like early release, like parole, and so on, all those things which go to the execution of the penalty. That's the basic and fundamental distinction one sees from Utley. And then the question is, how does Del Rio fit within that? And the answer to that, although, of course, one can see, you can analyse it if one starts with a blank sheet in various different ways, the answer that is given to that in the Grand Chamber itself, see paragraph 83, is not, as it were, to undermine the basic distinction I've just described on the contrary, to maintain it, see paragraph 83, but then to say, well, actually, in this case, you can treat the remissions as being part of the penalty itself.
The distinction isn't a matter of pure technicality. Remission is remission of sentence.
Yeah.
The sentence is changed.
Yeah.
Now, early release simply means that you serve part of your sentence on license,
Yes.
subject to good behaviour, with the possibility that you'll be recalled to serve it in custody.
My Lord, I hope I wasn't suggesting that it was an unprincipled distinction.
I wanted to dispel the idea.
The idea that it might be.
It's a pure legal technicality.
No, I'm certainly.
It makes a difference to the prisoner.
My Lord, I do respectfully agree. The point that I was making was simply one could have, as it were, lumped various things in various different boxes if you start from scratch, but they concluded you shouldn't do that. You should analyse the matter and see whether it does go to the penalty itself, as it was put in obeyed in paragraph 36, and that is what they've done. But everything else relating to execution does fall on the other side of the line. There is a clear distinction when you're, as you say, either serving it in prison or you're serving it on licence, subject to recall, and all of the various changes that have been effected there. The absolutely consistent Strasbourg authority and domestic authority says you treat those as distinct.
If you have the benefit of remission of sentence, does your record indicate any change in the term of imprisonment that was imposed initially? Is the sentence changed? You obtain remission of your sentence, but you still have been sentenced to, say, 5 years.
You have, but I don't know what the position would be as a matter of technical domestic law. Certainly in relation to the Spanish provisions being considered in Del Rio, as analysed by Strasbourg, they did regard that as being part of the penalty, whatever the technical position may have been under Spanish law.
I just think, well, in relation to accounts of previous convictions, the fact that somebody's got out on remission hasn't changed the sentences that have been imposed on their records.
Well, maybe not, but you're still in the same position in relation to early release periods, custodial period, and licence periods for determinate sentences. And I do respectfully submit that however you analyse it domestically, or however you analyse the relevant provisions of Spanish law, we're not quite in argenteratum locutum, but we're pretty close to that, because Strasbourg has considered these issues and has considered what Del Rio actually means. And I do respectfully agree with my Lord the President of the principled nature of that distinction. Can I then come to the submissions that we make on the back of that line of authority? And there are perhaps 5 key submissions we make on the back of that. Firstly, the relevant penalty, in inverted commas, for the purposes of Article 7 is, in a context such as the present, the determinate sentence imposed by the court. And under that submission, it's perhaps worth noting that the concept of penalty has an autonomous meaning. That's one of the points that comes out of the latest Ukrainian case, which I'll come back to, but it has an autonomous meaning, and both the Strasbourg and the domestic authorities have made it very clear that it is the whole of the determinate sentence which constitutes the relevant penalty. You see that, we saw it, for example, in obeyed in ECHR, paragraph 29, page 1093, without going back to it. The sentence here was 3 years determinate sentence. That was the penalty. It's a single sentence, and within it there were in our provisions dealing with the custodial period and early release, but that doesn't alter or affect the fact that for the purpose of Article 7 the penalty is 3 years in the case of Morgan.
Sorry, just on autonomous concept, I mean, the Grand Chamber says that in paragraph 81 of Del Rio.
Yes. And you get it, my Lord, sorry, I hadn't picked that up, but you get it repeated in the Ukrainian case. So that's the first submission. The second submission is that there is a clear and important distinction in the authorities between the sentence, as so described, and the manner of executing the sentence. You get that from Utley, ECHR in particular, the two paragraphs at the bottom of page 1183. You get that from Del Rio Prada, paragraph 83, page 1125. You get that particularly from Abedin, ECHR, paragraphs 32 to 34, and 36, applying it on the facts. And it is worth perhaps going at that point to Kupinski. I don't know whether my lords have that electronically or whether you need hard copies.
No, we have it electronically.
I'm very grateful. Then Kupinski, 10th of November 2022, it's the 5th section as you see. And the facts are slightly bizarre, I can confess. It was a transfer case. Sorry to say that, but just a little hard to follow quite what the Ukrainian courts were doing, it may be thought, with the greatest respect to them. It was a transfer case from Hungary. As you see from paragraph 6, the individual concerned, Mr. Kupinski, had been sentenced by the Hungarian court of premeditated double murder for motives of personal gain. His home country is Ukraine, so the Hungarians are keen to transfer him back to Ukraine. There are various shenanigans in relation to that, but eventually he is transferred to Ukraine, see paragraph 10. And there's then obviously some form of process requesting the enforcement of the applicant's sentence, brackets, in Hungary, by the Ukrainian court. So it goes to the Ukrainian Supreme Court, and they have a think, it appears, as to how the Hungarian sentence should translate into Ukrainian law, which no doubt is a standard feature of transfers, but I hadn't come across it before. Anyway, you'll see what the I think it's the Ukrainian courts then do, and they initially goes to the Court of Appeal in Ukraine, I think. Zakarpattia, I think, is a Ukrainian Court of Appeal, and they decide, as you see in the second half of paragraph 12, that the ultimate punishment imposed should be life imprisonment without forfeiture of property, but with the possibility of seeking release on parole after 20 years. So that was directly reflective, as it were, of what the Hungarian courts had done. You see that from paragraph 6, if you just cast an eye back to paragraph 6. So the key bit is that the Hungarian courts say after 20 years you get the possibility of parole, and when it first comes to the Ukrainian courts, that's what they conclude is the translation as well. And that appears then to have been upheld by the Ukrainian Supreme Court. I think it's the Ukrainian Supreme Court that's being referred to in paragraph 13. You see the reference to parole after 20 years at the tail end of that paragraph. There's then a request for parole, and if my maths is right, that first request is made to, again, I think it's to the Ukrainian court, the Izyaslav District Court of that Ukrainian region. I think it's the Ukrainian region. Quite why the application is being made at that point, I'm not sure, but it appears to be being made after 14 years rather than the 20. Anyway, the optimistic application is made, and it is rejected inter alia, as you see in the final sentence of paragraph 14, on the basis that despite what the Ukrainian courts have previously done in the translation exercise, Ukrainian legislation, reading from the top of page 3, last sentence of paragraph 14, did not provide for release on parole for life prisoners. And that was the essential problem. And that then gets translated through into all of the various other domestic attempts, domestic in the context of applications to the Ukrainian courts to try and get parole after 20 years or more. Sometimes they say you haven't reformed, sometimes they say there's no possibility anyway. But it's a bit confusing on the facts, because quite why they're considering whether he's reformed or not if there is no Ukrainian possibility for this sort of sentence is a bit of a mystery. And it's a bit of a mystery as to why they were doing all of this in circumstances in which their own courts, that's the Ukrainian courts, had translated the sentence in the manner that you see in paragraphs 12 and 13. So I hope not without disrespect. The facts are somewhat puzzling, but the core point is that ultimately the Strasbourg courts take takes the Ukrainian court's position to be that summarised, to go to the tail end of the chronology in paragraph 23, namely that the relevant domestic law, that is in Ukraine, did not provide for release on parole or commutation of the remainder of the life sentence for life prisoners. So what in effect had happened was, whatever the intermediate stages and whatever the puzzlement on the facts, what seems to have happened was he gets transferred with a sentence that carries the possibility of reduction within itself after 20 years, and the Ukrainian courts in effect say, well, there isn't that possibility, so the reducible becomes irreducible, and that leads to a problem under Article 3 on Kafkaras grounds, which you'll be very familiar with, but it also leads to a problem and a finding of violation, as it turned out, in relation to Article 7. The Article 7 analysis starts at page 11, paragraph 44, and you'll see the essential nature of the problem as I've just described it in the second line of paragraph 44. The Ukrainian courts have converted that sentence, that's the Hungarian one, into what turned out to be a de facto irreducible life sentence, which was a heavier penalty. And it was that was said to lead to the violation of Article 7. They consider the applicability of Article 7 in the paragraphs between 45 and 56, and then they come to the merits of it, if it does apply, which they conclude it does. Just to show you the structure of the judgment, they come to the merits of it in pretty short form at paragraphs 63 and 64 under merits. So going back to paragraph 47, you'll see the reiteration of the distinction from paragraph 83 of Del Rio.
I'm just thinking aloud that it occurs to me that part of the background to this may be the long line of cases treating the fixing of a tariff in cases of indeterminate sentences. The fixing of a tariff is treated as a judicial exercise. It must be a judicial exercise because it's treated as part of a sentencing exercise.
Yeah.
One sees that in T&V, and then
yes,
a whole series of British cases about that, which brought about the Welsh, I think was another one. It brings about the reform of our system in the probably the 1990s.
Yes, my lord, I think you're right, and one needs to be a bit careful going to this because this is in that ilk. This is life sentence. With all of those considerations, it isn't determinate, but I go to it simply because it reinforces that basic distinction that we saw from Utley, that we saw from Abedin, that we see from Del Rio, paragraph 83, which is of particular relevance. However, this gets resolved in its particular circumstances with it being a life sentence, as my lord has indicated. We see that same distinction being dragged over with very clear effects into the determinate sentence sphere. And you see that there is reinforcement of the distinctions that are then drawn in paragraph 47, execution versus penalty. The reference to autonomous, I'm sorry, my Lord Sells, I picked up in paragraph 81 of Del Rio, so it's there as well, but if you wanted it here too, you see paragraph 49, about halfway down paragraph 49, the concept of penalty in Article 7 is, like the notions of civil right and obligation or criminal charge in Article 6, autonomous in scope. So it's got to apply across the Council of Europe, effectively. And then you'll see the reference to Welsh, which may reinforce, my Lord the President's point at the bottom of that page. And you'll see their reasoning in paragraph 51, and then again in 55, a reference to autonomous concepts of penalty, first line of paragraph 55. And you'll see the ultimate analysis when you get to 63 and 64 is This is the distinction, and it's pure sentencing. This is the distinction between a reducible life sentence and an irreducible life sentence. That's ultimately the reasoning, and the government of Ukraine didn't make any observations, as you see from 63, but that's the essential reasoning.
In paragraph 52,
Yes.
They say that irreducible and reducible life sentences differ as to their scope,
Yes.
which clearly Ventnor and others cases would suggest. So the change from the absence of a parole system in Ukraine is treated for that reason as
And exceptionally,
altering the sentence.
exactly so. That's the essential reasoning. So they have to get it onto that side of the line, and they do for that reasoning, and for, perhaps understandably. I mean, my lord will no doubt recall all of the challenges post-Vintner in our courts to whole life sentences. But my lord, that is exactly the reasoning. And you see that perhaps very clearly from para 64 if you cast your eye forward to that.
Yeah.
Yeah, it's the same point. So we respectfully submit that's yet another in a long line of authorities which go out of their way to draw this distinction between, on the one hand, the sentence, which we know from earlier cases means determinate sentence, as I indicated in propositional submission 1, and on the other hand, things that go to the execution. This was a very unusual case for the reasons that we've explored, but the conclusion is that it's on the sentence part of the line because of the difference between a reducible and irreducible sentence, essentially. It's that Vintner point reflected in paragraph 64. That's the second submission, therefore, and it's a submission which is based on that whole long line of case law culminating in the very recent Kopinski case. The third submission is that clear and important distinction aligns, in the context of determinate sentences in particular, but aligns with the Strasbourg and domestic authorities on Article 5. The Article 5 case law, as we will see when I come to it very briefly at the end, makes it clear that the whole of a determinate sentence is the penalty imposed by the court for the commission of an offence, and any detention during that period, whether or not you've been released and recalled, but any detention during that period is therefore in accordance with Article 5(1)(a). The original sentence justifies the detention for the entire period, and you'll be very familiar with all of the authorities that go to that. You have in the bundle in particular, to name but two, Whitson. I don't invite you to turn it up now. Whitson is the top court authority on that. Paragraphs 38 and 39, page 1083. But you also have, if necessary, Brown and the Parole Board, paragraph 58, 58, at page 1625. And it might be thought that it would be very odd and might cause principled asymmetry if Article 7 precluded you from modifying the manner of executing a sentence in circumstances where the continued detention of an individual would, from an Article 5 perspective, remain entirely lawful. That's the third proposition. The fourth proposition is that Khan and its reasoning and conclusions about this primary legislation is entirely in line with that constant domestic and ECHR jurisprudence. Can I just invite you to go back to Khan, if you would, page 1019. We looked at the justification analysis under Article 14, but just to show you the paragraphs without trawling through, because I've done the laborious exercise afresh, as it were. But if one goes into the judgment, the relevant bit dealing with Article 7 is the passage that starts at paragraph 84 on page 1039. And you will see from the paragraphs and the pages that follow that the analysis, all to do with the 2021 Act, that the analysis asks and seeks to address what they describe as the fundamental question at paragraph 86. And they then analyse all of the relevant case law, focusing in particular, for understandable reasons, on Del Rio, then they go through the other authority, Abedin, paragraph 95, which I've taken you to. Hogben, which you'll recall was referred to in Abedin, they analyse and recite a relevant bit of in paragraph 97 at page 1041. And you'll see they've highlighted that particular bit from paragraph 4 of Hogben. Utley, House of Lords, in 98, citing paras 38 and 43, which we saw earlier. Then Utley in the United Kingdom, para 99. Robinson, paragraph 100. The consideration of Del Rio and Abedin, Divisional Court 102. Abedin, United Kingdom 103. And then the conclusions that they reach, just if I could invite you to read 104 and 105 on page 1044. Those are the conclusions that they draw from the case law that they've just analysed with some considerable care. In effect, founding on what we describe as the core distinction. And my short submission is that that was entirely correct as an analysis of the relevant domestic and ECHR case law. Just so you note it, you'll see the title above paragraph 106, which is Article 5, and to save me having to go back to it, the Article 5 analysis of the Divisional Court, was a challenge specifically on Article 5 there, and their Article 5 analysis culminates in the key paragraph drawing out their conclusions of principle from the case law that they analyse at 121, bottom of page 1048. So those are the key principles under Article 5 that they draw from the case law, and no problem under Article 5 either, is the conclusion of the Divisional Court with the 2021 Act. The fifth submission that I make comes more directly to the approach of the Court of Appeal in Northern Ireland, and the submission, it's a little complicated, but the submission is this, that for the purpose of Article 7, there is no distinction between a legislative scheme that provides for automatic release at halfway, followed by release on licence for the rest of the period, i.e. the English position of the 2021 Act, and B, a legislative scheme that provides for a judge to determine the custodial period subject to the legislative maximum halfway, with the relevant licence period then following and covering whatever remains of the determinate sentence. Why do we make that submission if I'm allowed to do an A, B and C under that fifth submission? The first point we make in support of that broad submission is that the distinctions drawn by the Strasbourg case law and the European Court of Human Rights are distinctions of principle. As such, they apply to Article 7 in relation to all the various systems in operation in the contracting states. In other words, autonomously. And you'll recall that idea, paragraph 81 of Del Rio, Kopinski 49 and 55. The distinction which is drawn in the Strasbourg case law under that autonomous meaning is one of subject matter. In the determinate sentence context, it is between that sentence, that determinate sentence, 3 years, 5 years, 20 years, whatever it may be, on the one hand, and on the other hand, the provisions that govern early release or release on licence. And for all the reasons I've gone through and the Strasbourg court and the domestic courts have explained, that is the distinction which we submit is soundly based and is entirely consistent with the approach to determinate sentences under Article 5. Second point under this broad submission, the distinction that has been drawn and the clear and obvious synergies between that distinction and the Article 5 jurisprudence is not in any sense qualified or undermined depending upon identity, i.e. depending upon who it is that is responsible for the measures involved in the execution of the sentence subject matter. There's nothing in the ECHR case law, goes back to a question that my Lord Burrows put to me, there's nothing in the ECHR case law we submit to suggest that the subject matter distinction in effect disappears if only there is any judicial involvement in those areas at the point of sentencing. And one can see that, amongst others, from Abade in ECHR. The argument in that case was that the prisoner's entitlement to automatic release at the 3/4 stage of his sentence formed part of the scope of the penalty. And the court said no, it can't matter where that entitlement to automatic release derived from.
It's, the point may be illustrated by the fact that in some of the member states of the Council of Europe, the whole system of early release is administered by judges.
Yes.
I have in mind, well, certainly France, where they have what they call les juridictions de l'application des peines, with a first instance judge who deals with release on license, also sort of temporary exeats.
Yes.
Whether you're transferred to an open prison.
All under judicial oversight.
And then there's a whole system there's an appeal tribunal and there's a further appeal, I think, beyond that. And I believe that model's followed in other French-speaking countries. Oh yes, I defer, of course, to your greater knowledge of those local systems. But the point is good, I respectfully submit. It's at heart a distinction between subject matter area as the foundation for the principle, and the suggestion that the thing actually all depends upon whether or not you've got some part of judicial involvement involved, or whether or not it's set by legislation. And that perhaps leads to the third sub-point under this submission, which is that there would be, and is, I submit, no principal basis for it all depending on whether or not there's been judicial involvement in those areas at the point of sentencing. The involvement of the sentencing judge in, for example, custodial period does not touch the two fundamental points of principle that A, the penalty is the determinate sentence, and B, the early release mechanisms concern the manner of execution of the sentence and not the penalty. Nor, at a more basic level, does that involvement touch the basic comparative exercise that Article 7 entails. That exercise, at its most basic level, focuses on the actual penalty and the compared penalty once the law or the policy or the judicial approach has changed. Not on the manner in which the penalty came to be what it was. So the distinction drawn by the Court of Appeal in Northern Ireland is, we respectfully submit, a difference, not a conceptual distinction. If one accepts, as the Divisional Court did in Caen, that it is permissible for the legislature to change the early release period from the halfway point to the 2/3 point, it can make no difference in principle that in Northern Ireland it was the sentencing judge that set the early release period at the halfway point,
or in some cases at a lower point, subject to the legislative maximum. So there's a kind of split between legislation setting the maximum and the judge having some limited discretion to take it down a bit. If, and it's perhaps a separate point, but if the Northern Ireland Court of Appeal are right, the judicial involvement would operate to preclude any alteration by legislation post-sentence, even though such changes have been found repeatedly to be compatible in principle on the basis of the existence of a covering determinate sentence. And that would create a slightly ironic position when judged as against the fundamentals of convention standards that are usually applied, because it would put a premium on contracting states removing any form of judicial consideration of these issues at the point of sentencing. Why would Article 7 wish to do that? Especially if they're prepared to countenance automatic provisions, whether through policy or through legislation, and the changes that they effect on the practical impact of a sentence on a prisoner, how long you serve in prison and so on. Indeed, in the present context, the involvement of a judge in having some input into the custodial sentence would have the effect, as it were, accidentally or adventitiously, of tying the hands of the legislature in future in relation to precisely the sort of legislative changes that are otherwise entirely acceptable under Article 7, simply because a judicial role of some description is conferred. That seems, if I may respectfully say so, not merely strange in terms of the fundamentals underpinning Article 7, but strange as an interpretive imputation to Parliament, because they've effectively set up a fundamentally different system in England and in Northern Ireland. But the basis for the distinction seems very, very odd, and at least in principle. One can posit hypothetical cases, but one can posit, for example, release after 30% is served is the original legislative rule, let's assume, and that's then changed by legislation to move from 30% served to 75% served. Now, that's the first example. Fine. No difficulty on anyone's case in relation to Article 7, because the changes are all legislative, there's no judicial interposition. That's absolutely fine, but quite a whopping change, 45%. The contrasting example, hypothetically, would be some tiny discretion conferred on the court at the point of sentencing, maximum 50%, after which you get released, and then the judge has, let's say, a discretion as to 5%, so you can take it down to 45, and that then is changed by legislation to 75%. Incompatible. What that illustrates is that on the Court of Appeal's reasoning, it appears that any involvement of judges at the point of sentencing, even in relation to things that are to do in subject matter terms with the execution of the sentence, is fatal and operates as a preclusion in Article 7 terms to future legislative change. Now, again, one can take this in a variety of different ways, but if the House of Lords in Utley, the pure and strict approach of the House of Lords in Utley was right, and one needs to be a little bit cautious of it because it's quite a savage doctrine on one view, and whether it would quite survive Strasbourg in precisely that form may be open to question, but assume that it's right. Article 7 doesn't touch matters unless they overtop the maximum sentence that could have been imposed anyway at the first point. And it's irrelevant, says Lord Roger and the House of Lords' reasoning in Utley, even to predict what a judge might have done. I think it was paragraph 42, let alone what the judge in fact did. But even if you go with the distinction that sits in Utley ECHR and all subsequent cases, the focus is not on the identity of the actor at the prior point of comparison, on whether a judge is given any discretion at the sentencing time to consider issues relating to custodial period. The focus is on whether or not you are in the subject matter territory of an actual determinate sentence, providing lawful authority throughout its currency, or in territory where where the subsequent change in effect affects that subsequent affects that determinate sentence in a way such as it did in Del Rio Prada.
Can I just check, am I right in thinking that Article 7 is a provision which can't be changed even in emergency conditions?
Because in Article 15 is it referred to? We can check in a moment, I think.
Perhaps if you could. It just seems to me that potentially that's a relevant aspect of what you're talking about, because that would mean it's not just in terms of the ordinary operation of the convention that the legislature's hands are tied. They're tied
even in an emergency, you couldn't do it.
Emergency situation, but
yeah.
But sorry, I haven't looked that
No,
up.
I'm sure we can find that out. Someone can give us an answer to that. So, my lords, those are the 5 submissions with the 3. So sorry.
I think that's right. I've just got it in front of me here. Article 15.2 says no derogation from Article 2 except in respect of deaths resulting from lawful acts of war, or from Articles 3, 4, paragraph 1, and 7 shall be made under this provision.
Thank
you.
you.
It's non-derogable.
Yeah, I'm grateful. I'm grateful for that point. My lords, those are the 5 submissions. We submit that there is therefore the court is confronted with a position where you're not really in the territory I'm about to come to, because there is clear and constant jurisprudence all going one way in favour of the answer that we respectfully invite the court to espouse. There is, of course, theoretically, as it were, for you, an alternative way of framing this analysis, which is through the AB doctrine, if I'm allowed to call it that, namely the doctrine that the court considered in that case to do with solitary confinement of juveniles, where the court reconsidered Ulla and all things to do with Ulla, and explained the basis on which Ulla proceeded in principle, and arrived at the expression of the now well established and well known test, if that's the right way of describing it, of the court having to be fully confident, as it was put, I think, on 2 occasions in paragraph 57 of AB, page 999 in the electronic bundle. Don't invite you to turn it up. But that effectively said, you, the domestic court, before making a jump into the somewhat unknown, as it were, have got to be fully confident that that's the answer that Strasbourg would give, because otherwise the constitutional door, e.g. for the government to go to Strasbourg, is closed, and closed permanently. That was the doctrine set out and reanalysed in AB and applied, if I recall, subsequently in the Alan Kane case about X in the passports. And our submission, if necessary, which we respectfully submit it isn't, because the clear and constant jurisprudence is all the other way, is that you can on no view be fully confident that the Strasbourg court would say what my learned friends have to assert it would say, namely that the interposition of any judicial discretion at the point of sentencing renders incompatible under Article 7 any subsequent legislative change, even to things that fall within the subject matter area of execution of the penalty. Well, that's all I wanted to say in relation to Article 7. Article 5 I can be very much shorter with. The submission in relation to Article 5 is that the whole of the determinate sentence is the penalty imposed by the court for the commission of the offence, and any detention during that period is in accordance with Article 5.1a, even if you've been released on licence and dragged back in and so on. I gave you Whitson earlier on, 38 and 39, page 1083. Also covered the Article 5 arguments in a Badin Divisional Court, paragraphs 20 to 21. Again, I'm not going to invite you to turn up any of these references, but 20 to 21 at page 1013. And our submission is that there is a commonality of principled approach between 5 and 7, including the core distinction that I've identified under Article 7. And it's right in principle that that should be so, because there would otherwise be incoherence between the 2 articles. Del Rio also provides no succour or assistance to my learned friends here, just as it did not in Abadim when that was analysed by the domestic courts. The relevant reasoning of the Grand Chamber in Del Rio is contained in 130 to 131. Here, of course, there is no right to early release. The expectation, according to the consistent English and Strasbourg authorities, that there's a plain distinction between sentence and administration and execution, and that applies here too. So our short submission is that the Divisional Court's analysis in Khan, which I referred you to when we were in Khan, especially the propositions derived from the Article 5 case law in 121 of Khan, is correct, and that all of the conclusions of principle that they reached in 121 of Khan are equally applicable in the context of Northern Ireland. And of course, my lords, A-B applies here too, if you need it, which you don't. So we respectfully submit that although, of course, the Court of Appeal in Northern Ireland said, well, we don't need to go to Article 5, even though they went as far as to say we disagree with some of the approaches of principle set out by the Divisional Court in the context of Northern Ireland in relation to Article 5, we respectfully submit that if and to the extent that they did disagree with those, they were wrong to do so. Those conclusions are well founded in principle on the authorities that were cited by the Divisional Court in Khan.
And just on your coherence point, I mean, it seems to me that paragraph 130 in Del Rio supports that fairly directly, because it runs together the foreseeability required in relation to law and lawfulness for the purposes of Article 5 with the considerations that they'd already discussed in relation to Article
7. Exactly so. I think it was one of the two paragraphs I gave you. Yeah, 1138. My lords, so those are my submissions, and on the principle that if you leave a difficult question long enough, someone else will pick it up. My learned friend, Mr. McLean, has, I'm delighted to say, agreed to address you on Article 8 and those matters and the question that the President raised. But, my lords, unless I can assist you further, those are my submissions for...
No, thank you very much, Sir James.
I'm very grateful.
Mr. McLean.
Can I deal firstly with the question Lord Stevens raised about the warrants in this case? The court will have picked up from the core volume that there's been multiple strands of litigation in respect of these individual defendants. And the first strand of litigation was a habeas corpus application that was dealt with in August 2021. And there's a judgment in respect of that at Electronic 260. And the issue of the committal warrants was in play at that stage of the proceedings. You'll see some discussion of it at paragraph 8, that's page 262. And then the court, which was composed of the Lady Chief Justice and Lord Justice Tracy, dealt with the issue at paragraph 39, that's page 273. An argument had been raised about the committal warrants. The parties have indicated there's no statute provision which guides the issue of a committal warrant. In a case such as this, it's clear the change in laws found in the legislation. So whilst there are some arguments about the wording of the amended committal warrant and the process, these are not, we consider, sufficient to invalidate the lawful detention in this case. The contemplation of legislature was that it proceed to be administrative rather than judicial.
So which paragraph is that, sorry?
That's 39 of the habeas corpus decision, that's page 273. Now, going to the committal warrants itself...
I'm sorry, just give us a moment to read paragraph 39.
So when they're talking about the amended committal warrant, that's a warrant that was issued after the coming into effect of the legislative change, is that?
Yes.
Is that right?
What happened was, after the legislative change came into play, the Northern Ireland Prison Service wrote to the Northern Ireland Court Service saying, we think these cases should go back before the sentencing judges. And there was then discussion and liaison with the Office of the Lord Chief Justice. This is all set out in correspondence, inter partes, in the habeas corpus application. Correspondence and engagement with the Lord Chief Justice's office, and the decision of the Lord Chief Justice, I think of the 17th of June 2021, was that the matter need not go back to the sentencing judges, that the change would be affected by operation of the legislation, and the warrant altered accordingly. So when you see the warrant, I think the warrant, my Lord Stevens flagged, was at page 471. You will see the middle paragraph states, following the commencement of Article 30 of the Counter-Terrorism and Sentencing Act 2021, the above sentence was amended to reflect the revised mandatory custodial period set out in the statute. Accordingly, on the 17th of June 2021, the sentence passed on 13th November 2020 was amended. It was amended, so the committal warrant is amended by Northern Ireland Court Service to reflect the statutory change.
Using Mr. Justice Coulton's name at the bottom of it.
Yes, and not changing the date. So there are imperfections about that, which is what the divisional court's alluding to in paragraph 39 of the judgment. But in terms of the substance of the change, the matter did not go back to the court, so there was no further.
So in effect, this is done on the direction of the Lord Chief Justice within the court service, essentially authorising relevant officials within the court service to issue a new amended warrant.
Because the warrant provides the basis for the continued detention of the person in custody.
I understand this is a warrant. I'm just trying to see how we get to the relevant warrant here.
That's how we got to that position. Yes. But it didn't go back to, there's no more involvement of the sentencing judge, there's no more judicial determination, there's no change by Mr. Justice Coulton, which was...
Can you give us, do we have in the bundle the Lord Chief Justice's letter, just so we can see that as well?
We can, it's not in the bundle, but we can obtain the correspondence and the emails that relate to that, but it was shared with the appellant, the applicant in that case, Mr. Morgan, who's one of the respondents in this case. So there's...
yeah, I mean, speaking of myself, it seems desirable that we actually do understand the mechanics of how we got to the relevant orders.
We'll ensure that that's made available with the agreement of the other parties. But the point was raised in the habeas corpus judgment, essentially run to ground, and that's the explanation for this rather unusual looking warrant, which appears to bear different dates. But it's the, by operation of statute, the change was made. On one view, this is entirely unnecessary because you have lawful authority as a result of the provisions of primary legislation in any event to continue the detention. So it's belt and braces, not necessary for this to have occurred, but that is the explanation for the committal warrant. Turning to the question the President raised about the operation of Article 8 of the 2008 order, if the court can go to page 514 electronically, it's probably helpful to start with Article 7.
Sorry, just before we move on, I just want to get clear in my mind the point you touched on just now very shortly, that on one view the revised order was unnecessary, and presumably that's on the basis that you have the original order which says what the sentence of custody is.
Yes.
You then have legislation which tells whatever is the relevant official, well, perhaps the prison governor,
Yes.
what to do in the light of a sentence of that kind when the licence period applies. And so that the prison governor, I think this is the point you were making,
Yes.
but you made it so fast that I just want to make sure I've understood. The prison governor, theoretically, doesn't need a further order. He's got the order on which he's basing the detention and refusing to let someone out while that order has effect. And then he's just told by primary legislation when the licence period begins. That's the point you're making.
That's precisely it. The governor must read the order. He has to understand on what basis he holds the person. He reads the order in light of the direction of the primary legislation, which tells him now the period is 2/3, not 50% of the custodial maximum. So that's the basis. So if you didn't have the warrant modified in this way, the governor would still have the same instruction by virtue of the primary legislation.
Yes,
but
he'd have the two things he needs: the sentence of custody imposed by the judge, 3 years, and someone authoritative, in this case Parliament, telling him when the licence period starts.
Exactly. So the detention is lawful on that basis. So
although the practice in Northern Ireland, which is certainly different from the practice I was used to in Scotland, although the practice in Northern Ireland has been to record on the warrant for committal both the sentence and also how it's divided between the custodial period and the licence period, that second aspect of it can be overruled by legislation without any need for a fresh committal warrant. One can see as a matter of administrative clarity, it no doubt is helpful for the prison to have an amended warrant which stipulates the new dates.
exactly. And that's why the prison service came to court service to say initially we need to have something that makes the position clear. And through that process of engagement, one has the amended warrant, albeit, as I've submitted, not critical to the legality of the detention. Sorry, different topic. The question the President raised in respect of the operation of Article 8 of the 2008 order. And I was inviting the court to go to electronic 514, which takes you to Article 7, which is the provision in the 2008 order which specifies the length of custodial sentences. And you'll see Article 7.1, this article applies where a court passes a sentence, A, of imprisonment for a determinate term. That's this type of case. And then I invite you to look to Article 7.2, subject to Article 14, and the statutory provisions mentioned there. The sentence shall be for such term, not exceeding the permitted maximum, as in the opinion of the court is commensurate with the seriousness of the offence or combination of the offences. So that's the sentencing exercise, the specification of the length of the custodial period. That is a conventional sentencing exercise. And that applies to the imposition of a DCS, determinate custodial sentence, which is the sentence that's in play in these cases. The Article 8 provision does something different, and I'm here probably affirming the background to the President's question, that this is not about the conventional sentencing exercise. This is a provision dealing with the length of the custodial period. And just to go through the provision, you'll see that 8.1, there's a two-stage process contemplated here. First of all, the court passes a sentence of imprisonment for a determinate term. So that is the overall penalty, whatever it happens to be, the 3-year period. Then the rest of the provision deals with the internal organisation of that sentence, and that will involve a split between a licence period and a custody period. And the judge has to exercise a discretion about how he organises that internal split. He doesn't have a completely free hand because there's a maxima that applies in respect to the custodial period. He can reduce it below the halfway mark, but he can't increase it above that. So the judge has to engage in an exercise of striking the balance using discretion between licence and custody. And you'll see, then looking to Article 8.2, the court's required to specify a period, referred to as the custodial period, at the end of which the offender shall be released or is to be released on licence under Article 17. The custodial period shall not exceed 1/2 of the term of the sentence, so that's the maximum provision. Subject to paragraph 3, the custodial period shall be the term of the sentence less the licence period. And then 8.5 provides the factors for the judge to weigh whenever he's determining the duration of the licence period.
So he actually, what he has to consider is the appropriate licence period.
Yes.
And then the custody period is simply the result of a piece of arithmetic.
Exactly. Yes. Limited by a maximum.
And then we see in 5 the factors that he's to take into account.
Yes. So there are 2 factors, public protection, and second is prevention of commission of further offences.
So he is not taking account of deterrence, he's not taking account of retribution, he's only concerned with risk.
Yes. This is more analogous to a parole board or parole commission function being discharged by the judge than it is to a classic conventional sentencing function. And the factors, as the court can see, are bounded and constrained: risk and the prevention of the commission of further offending.
And perhaps most importantly, he's not concerned here with punishment.
No. Because all of that, the Article 7 deals with the sentencing exercise, the seriousness of the offence. The term is then specified, and that engages the machinery of Article 8, which brings in these different considerations. So the nature of the judicial rule is very important. Our Court of Appeal clearly thought it was a significant conceptual distinction that brought a difference between this case and Can. Sir James has dealt with it. We say it's not properly analysed. You can see that the discretionary exercise here is one of modulating or moderating the duration of the licence period against defined factors. It's also, my Lord, significant if you look to Article 8.6 that this is not a remission scheme. Remission shall not be granted under prison rules to the offender in respect of the sentence. So it's expressly not a remission scheme. We don't have it in the authorities, but remission is a defined statutory term. It's in terms of the prison rules, its foundation is found in Section 13 of the Prison Northern Ireland Act 1953. And there's a requirement in the statute to make provision for remission. And that's disapplied in respect of an Article 8 process. So it's expressly not remission.
So does Northern Ireland still have provision for remission on the statute book?
In the rules, it remains extant in the rules.
Sentences under 1 year.
Yeah.
And release on remission, you
ends the sentence.
You aren't subject to any licensing.
Exactly. Yeah. Release on remission ends the sentence. Exactly. And I think that's probably specified in the 53 Act as well, or certainly in the rules. But it's an entirely different concept from what we're dealing with here, which is an early release regime internal to the overall envelope of the penalty, which brings this case squarely into Can-type territory and the Strasbourg jurisprudence that applies. So the answer in one sense is found in a careful reading of Article 7 and Article 8 of the 2008 order. My Lords, in terms of the split...
Back to subsection 5 then. The court thinks appropriate, that's the discretion.
Yes.
And take account of the effect of the offender's supervision by a probation officer and release from custody. One method, of course, is preventing the commission by the offender of further offences is locking him up.
Yes. You can only do that for so long, though. The maximum you can do is up to half of the sentence period. And indeed, in the terrorist-type cases, the default normal position is that they do spend half the sentence in custody. But there is a facility to reduce it, and a judge can reduce it down to whatever he thinks is appropriate.
So presumably 8.5 is really saying you only reduce below the 50% if you're really sure that supervision on probation and so on is sufficiently going to contain the risk of this offender that you can cut it down.
Bearing in mind you've already made the determination that a DCS sentence is appropriate, it requires a determinate custodial sentence, it may be unsurprising that it's going to be in fairly limited cases that you exercise the reduction down discretion, but the facility is there.
I mean, in a sense, focus on 8.5 brings out the nub of the dispute here, because, of course, Parliament, in passing the later legislation, is addressing risk factors itself. It's just saying, we think for this class of case, in the light of the experience that happened with the two incidents that were referred to, the risk factors need to be dealt with and managed in a particular way for this class of offender.
Yes.
So I mean, it is, I'm not sure this is the right way to put it, but it is just replacing Parliament's view as to management of risk for that of the potential view of the judge in a Northern Ireland case.
Yes, again, by moderating the maximum, taking it up to 2/3, one view being that that additional period in custody may allow for greater work in terms of risk reductive behaviour, reducing the risk to the public. That's one of the purposes, I think, which Sir James highlighted in his presentation of the overarching 2021 Act. So the purpose.
Your submission, sorry,
my Lord.
I think your submission would say that it doesn't really matter how often the judge does actually depart from what I would call normal position by the exercise of his discretion. I think your submission would be it makes not a scrap of difference. But have we got any evidence on that as to how far judges do actually depart from the normal position?
No, I think there's no formal evidence before the court. I think their counsel here are experienced on PPS prosecutions and terrorist trials. I think their view would be it never happens in terrorist context, generally speaking. But we can't think of examples of that.
But yes, certainly that has been my experience as well. But I was just wondering what the mechanics of 8.5 are. Say, for instance, one gets a pre-sentence report which is highly favourable, and so there's a particular course. If the offender goes on it, it will protect the public and will prevent the commission of further offences. Are those the only factors the court can take into account? For instance, in a terrorist case, the idea that society's outrage at the commission of undermining society by committing terrorist offences, that plays no part at all, is it?
Well, the factors are confined to those that appear in Article 8.
And so the judge will be compelled, in the exercise of discretion, if he accepts the pre-sentence report, to extend the licence period.
Yes, he's entitled to form a view about it, on the merits of it, but yes, he could.
If he forms a view which is that the terrorist will, there will be protection of the public and it will prevent the commission by the offender of further offences, he is compelled in such circumstances. If he accepts that report, he's compelled to release a terrorist back on the streets.
Not release, no. He's
or to accommodate the extended licence period.
He has to form a view about an extension of the licence period, or the duration of the licence period.
What other view can he possibly form if he has accepted
it can be any
report?
It can eat into the 50% custodial period, to whichever degree he considers appropriate. So he might think it takes it down to 40%, to 30%, or probably not to 0, I would have thought, in any context.
And the only factors he takes into account in considering whether it's appropriate is not the nature of the offence, but the risk to the public.
Yes.
So a terrorist or the most heinous of criminals would benefit.
Well, the provision doesn't differentiate in terms of terrorist offending. The later changes do, but the 2/3 changes differentiate in that regard. But in terms of the regular application of Article 8, it doesn't. So it makes no difference. Of course, it may those factors may militate against the imposition of a DCS in the first place. If there's very serious risk, terrorist offending of that nature, it may not be a DCS Article 8 case. But if it is, those are the factors.
I wonder if you may be painting yourself into a corner here. I mean, certainly the only factors mentioned of which account is to be taken are factors to do with risk. But one could read thinks appropriate as conferring a discretion which may not be confined to those factors. I mean, you might some people who commit, well, I suppose murder wouldn't be the person, but one can envisage situations where the person might present a low risk of reoffending, but nonetheless the gravity of the offence was such that a judge might be reluctant to extend the licence period beyond what it, might be reluctant to effectively bring about the person's release earlier by reason of the low risk of reoffending.
Well, it may be, in order that there is scope for consideration of other issues. What is probably worth reflecting on is that one of the reasons why we have the change to the 75% rule for terrorist offenders is that prospective evaluation of risk in terrorist offenders is an extremely difficult exercise because the factors that identify risk for terrorist offenders are not the same as the factors that identify risk for ordinary offenders. They're ideologically driven. Their recidivism actions are not the same. Therefore, one of the means of dealing with that uncertain risk profile is to increase the protection to the public by moving from potential 50 to a statutory requirement of 2/3. That's how it's dealt with, and that's the intention of Parliament in making the change.
Like Lord Reid, I have difficulty in construing the word appropriate as excluding elements such as the revulsion right-thinking people feel in respect to the offence. And indeed, I could imagine a situation where the courts are brought into disrepute if the only factors that they could take into account were the risk of reoffending and in fixing the licence period.
Perhaps I can moderate the position. He must take into account at least those two factors.
Yes. But
Those are
then the exercise becomes balancing those factors against the other elements, which do involve punishment. Because reflecting society's revulsion involves punishing a person by depriving that person of their liberty.
That's done, my Lord, by the imposition of the determinate term. So the penalty.
The custodial period is the period which actually functionally deprives the person of their liberty.
It may well be, but the authorities which we've examined today speak with one voice on the point. It's the entirety of the determinate sentence and the term which is the penalty. And that's the basis on which the entire platform, which our sentencing structures, our rehabilitation structures, our recall, revocation is all built on that conceptual model. And we say it's important that that's maintained, and it doesn't require to be disrupted because of some posited incompatibility in this context. We say there's no incompatibility, but the soundest foundation to deal with this case, and it is consistent with Article 8, is to treat the first step, the 8-1 exercise, as the imposition of the penalty.
Yes. It may, I mean, again, this may not be, I'm no expert on parole, so I don't know, but this may not be very different from what the parole board does. But it strikes me that 5 looks as though it envisages a 2-stage assessment. First of all, the judge will have to assess the effect of the offender's supervision by a probation officer on his release from custody in protecting the public from harm and in preventing the commission by the offender of further offences. So one has to form a view as to what is that effect, the effect of the supervision on licence. And then the court needs to consider what licence period is appropriate to take account of that.
It's quite a difficult exercise for the judge, in fact, because they've got to look forward to not the person as they're standing in the dock now, but sort of speculating how they're going to be in 1, 2, 3 years' time, and whether the risk profile they have then is such that probation, what one knows about probation, is going to be sufficient to manage the risk. I'm not saying it can't be done, but it's quite a strange exercise.
Yes, well, it's
a difficult exercise.
It's a challenging exercise for the judge. We accept that. But none of that, we say, undercuts the conceptual model here.
No.
In respect of...
But I mean, just to bring out that that's an exercise looking forward, which is actually rather different from and more difficult than what the probation commissioners themselves have to do when they have someone that appears in front of them, because they've then got all the up-to-date information and can make a judgment at that point.
It's analogous to the probation role, or the parole commissioner's role, but it's not the same. It's prospective rather than reflective on actual engagement. One can get scenarios, of course, as well, where terrorist prisoners don't engage at all with probation services as a matter of practice. They disengage or refuse to engage, in which case the judge or even parole commissioners have no information to work with. So it is a challenging exercise both ways for a judge and for commissioners dealing with it.
Can I have your answer to my Lord Reid's point? And that is, well, it's a 2-stage assessment. First of all, you work out the effect. And then secondly, what licence period is appropriate to take account of that or of that and other things. Because, as you have rightly observed, I cannot think of a single terrorist in Northern Ireland that has had a greater period of licence than 50%. And so are other factors in play at that second stage?
Well, I think you have my answer in terms of the minimum factors that have got to be taken into account, those that are specified in the statute.
And I'm asking about the other factors.
Well, there are other factors available to the judge in the exercise of his discretion.
Like what?
Difficult to enumerate those, my Lord, because most of those factors, those will have been reflected in the original 8-1 determination of the sentence. That's why the judge has selected the term that he selected. Bear in mind, these offences resulted in a sentence of 3 years, but the maxima for these was either 10 years in many cases or life.
I've got no difficulty in imagining a situation where an offender who is convicted of a terrorist offence has been overborne by some other person who has reformed, and therefore his risk to the public is very small. But are you saying that the judge, if he accepts that, is then compelled not to take into account the nature of the offence that the individual had committed?
Well, I think I probably don't think I'm going to change the answer particularly, but he reflects in the Article 7 exercise, in imposing the determined term, the sentence that's commensurate with the seriousness of the offence. That's what he's required to do under Article 7. Article 8 is a separate exercise. That's about arranging the internal architecture of the custodial period and the licence period. So that's where the answer lies, we say. Reading the two provisions together.
So the answer is he is compelled to release on license because he's already reflected it in an increased sentence under Article 7.
Yes.
And you'll have to do some explaining to the public because I'm not quite sure the public will understand that.
Well, my lords, I think it's probably as much as I want to deal with in respect of that limb of the case, which was Mr. Eady's, Mr. James's focus. The aspect of the appeal that I was going to deal with was an issue in respect of remedy and whether or not the 2008 order or the provision in the 2021 Act are primary or subordinate legislation. You will have seen that in terms of the appeal and the notices of objection that came in, there was an application to cross appeal in this case on the basis that the provision in question was a provision of subordinate legislation and therefore the Court of Appeal had available to it options under Section 3 of the Human Rights Act or Section 6 of the Human Rights Act to read down or disapply the provision. And the gravamen of the argument essentially is that what the court should have done, rather than make a declaration of incompatibility of primary legislation, was read this as subordinate legislation, opening up a panoply of other options, including straightforwardly disapplication of the statutory requirement for the extended period. Now,
I mean, I think it would have to be that, wouldn't it? Because, I mean, Section 3 was available to the court even if it's primary legislation, but they clearly didn't think there was a compatible reading that was possible.
Yeah. This is, in one sense, that we can cut through some of the issues immediately because the Court of Appeal formed the view this can't be read compatibly. It goes against the grain of the legislation. There's nothing that can be done in respect of that. So they said, and it was not argued to the contrary, no party said, including the party that's now saying it, that this was subordinate legislation. So proceeding on that basis, if it can't be read compatibly, there's only one option available. That's a Section 4 declaration of incompatibility.
So sorry, just so I'm clear, in the Court of Appeal and at first instance not argued that this was subordinate legislation?
No, not argued. And in this court, there's an application to cross appeal on the point. This court granted permission on the 12th of May 2022. Don't need to go to it, but electronic 94 is the page number. And the court only allowed the cross appeal in respect of Article 5, so it's a confined cross appeal. Didn't allow this particular issue as far as we see. But the respondent, representatives on behalf of him, Mr. Heaney, have developed a detailed submission, electronic 160 to 170, on this point, contending that properly read, this is subordinate legislation which, pursuant to Section 6(1) of the Human Rights Act, a court can disapply. So there's an issue about whether this is properly before the court or not. I'll park that point for now.
Well, how can there be an issue as to whether it's properly before the court?
Well, I think it'll be said that the issue of remedy is before the court because it always is in play. It'll be said that the court hasn't closed that point out. We have addressed it lightly in our written submission. There's an extensive argument against us by the respondent, and I'm, subject to the court's view, going to respond to that. It is, despite that procedural objection, it is a point of some importance because there is some difficulty in terms of the definition of what is subordinate legislation under the Human Rights Act.
I mean, I'm not saying we can't deal with it, but one might think that on something like that, one would want the benefit of the views of the courts below, if it's such an important point.
Yes, I fully accept and agree, my lord, with that.
Okay.
The issue was raised in the High Court. As I said, there are strands to this litigation. The applicant, Mr. Heaney, brought a judicial review application separate to his criminal appeal. You have a judgment in the papers from Mr. Justice Schofield where he was faced with this issue about whether or not the 2008 order amendment was primary or subordinate legislation. And he refused leave on that point, and the issue...
So when you say refused leave for judicial review?
Refused leave to apply for judicial review. I think there were then applications to appeal that, which have not proceeded any further because the issue has been played into this appeal, subject to the court's view about whether it's granted permission on it or not. I take my Lord Sale's point. It's something on which the Court of Appeal has not expressed a view in this appeal. Mr. Justice Schofield has, in the High Court, expressed a view in the judicial review application. Our Court of Appeal in Northern Ireland has dealt with the point in a case called Close, which is in the papers, taking a broad view of what is subordinate legislation under the Human Rights Act. And the respondent, Mr. Heaney, in this case, is arguing that that's wrong. The Court of Appeal is wrong in respect of that.
Sorry, when you say taking a broad view of what subordinate
Yes.
legislation,
The point is
that more is subordinate legislation than not. But
yes.
okay.
The position is, Lord, if one...
It's the other way around.
Yeah, that's what that was. The thrust of what you were saying seemed to be the other way around.
Yes, the other way around. I'm sorry, my Lord, yes. A broad view of what is primary legislation.
The difficulty about Close is that it was common case in that it wasn't argued.
Not argued. Accepted. The Court of Appeal formed a view about it.
It just wasn't an issue.
Yes. Well, so there we have the issue. The issue is whether or not under Section 21F of the Human Rights Act, one takes a broad view of primary legislation to include orders in council, including orders in council which amend other primary acts. If you turn up the Human Rights Act, page 776 of the electronic bundle. This is the interpretation section. And in this Act 21.1, primary legislation means any public general act, and over the page at F, order in council, made in exercise of Her Majesty's prerogative, or made under Section 38(1)(a) of the Northern Ireland Constitution Act or a corresponding provision of the Northern Ireland Act, or 3, amending an act of a kind mentioned in paragraph A, B or C. And the point in Close, and the point that may be in play in this case, is whether or not an order in council, like the 2008 order, which amends other provisions of primary legislation in the form of acts, is thereby primary legislation.
So it's just F3 we're concerned with.
F3,
we're not concerned with 1 or 2.
No.
It means that we've refused.
Okay. Am I right in understanding that there was an application for permission to cross appeal on this ground?
Yes.
And this court refused it?
As far as I read the order, permission wasn't granted. There's a
I was looking at it. I was on the panel. I can't distinctly remember, but
Well, that's an end of it.
I think we meant what we said, that they had limited leave.
Lord, I'm only dealing with the point because, well, A, it's being argued and you're going to hear about it. We're the appellant, that's a respondent.
Well, we're not going to waste time hearing about something that we've refused permission to have argued.
Well, on that basis then, subject to anything I have to say in reply, I don't need to dilate further on it. Interesting though it may be.
I mean, it's an interesting point. In an appropriate appeal, the court may want to deal with it, but it's not, obviously, a decision has been taken that we're not dealing with it on this appeal.
Well, if the court's not dealing with it, the answer is simple. This is a provision of primary legislation. The only remedy available was a declaration of incompatibility. No other issue arises. But as I say, there are points raised which I can deal with in response if anything's necessary to be said.
Yes. Well, that's That's very sensible.
That shortens entirely what I was going to trouble the court with.
Right. Thank you.
Thank you.
So, Mr. Larkin.
My Lords, the point wasn't ours, but we do make a general remedy point because the court is obviously going to have to consider the issue of remedy depending on what view it takes of the substantive submissions on...
I'm so sorry to interrupt you. I fear that if you speak there without the microphone, someone will come and tell you that you need to have a microphone so that our streaming service can pick it up. So I'm sorry.
Thank you, my Lord, for that, for that guidance.
In fact, it's really best if you were to be in front of the two microphones there. I think it means you probably have to change places with Mr. MacDonald.
Well, that's I'm gratefully...
It's simply that the microphones have to pick you up for the live stream to have the sound of your voice on it.
Hopefully normal service resumes.
Yes.
So what I was saying is that the point to which my learned friend Dr. Gleelan has laterally alluded isn't our point, as the court will know from our printed case. But we do obviously make submissions on remedy simply on the basis that, depending on the view the court takes of the rival contentions on Article 5 and Article 7, the court's going to have to do something about that. And if the court finds in our favour, then the court will ask itself, well, are we confined to making a declaration of incompatibility, or ought something else to have been done by the Court of Appeal in Northern Ireland? And our submission on that is pretty straightforward, and it's simply that this case comes to this court on an appeal under the Human Rights Act, but in the Court of Appeal, what the Court of Appeal was dealing with was admittedly a fairly unusual appeal against sentence, but nothing more than an appeal against sentence.
I mean, the whole procedure here was wrong, was misconceived. There was nothing wrong with the sentence imposed by the judge. I mean, we're not going to make an issue of it now. It's water under the bridge, but these would properly have been, it seems to me, civil proceedings rather than criminal at all.
Well, the reason why the appeal was taken when the habeas corpus application in which we appeared was unsuccessful was because if we were right in our underlying contention about Article 7 and Article 5, the Court of Appeal was potentially in a position to do something practical in favour of the then appellants for whom we appeared, namely reducing the sentence to a level which didn't result in a breach of their convention rights.
Well, again, I mean, well, I can see we're able to go around in circles, but yes. Obviously if what we are really dealing with is early release, then the sentence isn't an issue at all, and the correct remedy would be, I suppose, a declaration reflecting what the correct position in relation to early release is. If we can do that, which you could then follow up, if need be, by an application for habeas corpus at the appropriate time, or if there are reasons why we can't deal with it by declaratory relief, then it will be a declaration of incompatibility.
Yes.
It could be left
well, in the case of both of the appellants, Mr. Morgan and Mr. Marks, for whom we appear, they've both been released in any event, so there could be no worthwhile adjustment in their sentence. But there could have been when we were before the Court of Appeal. Well, so I mean, I'll content myself simply on the issue of remedies by saying that, and I suppose looking at the fundamental issues in the case and the distinction that plainly exists between the position in England and Wales and the position in Northern Ireland, there are a series of references, some 5 in number, where the fact that a sentence is pronounced by a trial judge and that sentence remains unaffected is plainly regarded as significant. But can I, and I do this simply because the court has looked at it relatively recently. Can I invite the court to look at the relevant provisions of the 2008 order again? Yep. So my learned friend took the court to it in its original version, which I will do also by way of beginning. So we start with Article 7, AF page 514. And we've seen that the key exercise is the 7.2 exercise, and that is the sentence shall be for such term as in the opinion of the court is commensurate with the seriousness of the offence or the combination of the offence and one or more offences associated with it. Now, there is a provision to which reference has not yet been made, which is important in enabling the sentencing exercise to be seen properly in the round, and that's Article 9, which is at AF page 517. 9.1, informing any such opinion as is mentioned in Article 5.2 or 7.2, a court shall take account all such information as is available to it about the circumstances of the offence or, as the case may be, of the offence and the offence or offences associated with it, including any aggravating or mitigating factors. And that's important because that, I trust, responds to the concern expressed by my Lord Stevens, that in a way there was an abstract and apparently unduly limited approach to the evaluation and the assessment of factors that would be brought into play. But that's with respect to the seriousness. So that is, to use language which isn't in fact found in the order, that deals with retribution.
Right, but there the focus is on Article 7.2.
Yes, it is.
Not 8.
It is. But then when we come to 8, the length of the custodial period, and it's important not to pass this by in some unduly abstract or bloodless way, because for the individual prisoner, the predominant, perhaps the sole active consideration will be how long he or she actually spends in custody. And as we've seen, that period is arrived at through a separate judicial evaluation. And that's the evaluation that occurs in relation to Article 8, Paragraph 5. So the licence period is then, once one has the term of years pursuant to the exercise under Article 7 and 9, one then turns to the licence period. And that is every bit as much a part of the sentencing exercise as the evaluation that occurs under 7 and 9. And it has regard to the effect of the supervision by a probation officer on release from custody, A, in protecting the public from harm from the offender, and B, in preventing the commission by the offender of further offences. And essentially what we're dealing with there, in one sense, is under the second limb, a species of rehabilitation. It's in the interest of the offender that he doesn't offend again, and then public safety with respect to the first consideration. Now, it appears perhaps to have been lost sight of, but the reason why there is a maximum here of 50% is because the paradoxical effect is that if the more trouble someone is as an offender, the more one needs probation supervision in the community.
Sorry, we're talking, you say a maximum. In relation to the licence period, it's actually the minimum is 50%, isn't it? It could be anything between 50
it's
and
the maximum custodial period, but it is the minimum licence period. And the reason that is so because where one presents as an offender with difficulties, diction, one knows how prevalent that is, of course, in the general sense in the sentencing exercise. One would benefit more from an extended period on licence, and therefore one has the paradoxical effect that if someone presents essentially as an entirely reformed character at the date of sentencing, if there was no limitation on the licence period, such a person might then serve the full term of years, because the judge might entirely reasonably form the view that the entirely model prisoner now standing before him was in no need whatsoever of any form of post-release probation assistance.
We say he might serve a full term of years. You're meaning he might serve 50% of the sentence?
No, what I'm saying is, were it not for the limitation on the custodial term, the minimum period with respect to the licence period, one would then have the difficulty that if that wasn't there, an entirely model prisoner, judge would look down and say, well, this person plainly needs no assistance whatsoever from probation. So the unfortunate, perhaps paradoxical result would be that he or she would serve the full pronounced term.
I don't follow that. If the judge is confronted with an absolutely model person, isn't it going to be so much easier for the judge then to say, well, clearly this person can be released early because supervision by a probation officer almost don't need it, but so much the better that it's there. The risk to the public is minimal.
Well, no, my lord, it would be that would be absolutely the position if there was no rule for probation. But if probation is unnecessary, in other words, the person is an entirely model prisoner in every respect, then that simply wouldn't be required.
Well, it's an ingenious argument, but the judge has the alternative. I mean, the alternatives are either being in prison, supervised by prison officers, or it's being in the community, supervised on licence by a probation officer. And in the situation you're positing, the judge is obviously going to choose licence rather than custody.
Well, but would do so in a sense in the teeth of the provision. But I mentioned this because the issue about how to use this has been the subject of some authority in the Northern Ireland Court of Appeal, including in a case on which my Lord Stevens sat. Now, that was a case involving a sex offender, and I'll perhaps look at that after the short adjournment, perhaps.
Yes, if we've reached a convenient moment.
Thank you.
We'll adjourn now and it's 2 o'clock.